Welcome everyone to this new episode of the Privacy Rules Privacy Espresso series, a series where we delve into the latest news on privacy and cybersecurity from all over the world, together with the experts of the Privacy Rules Alliance and in some cases with guest speakers. In our talk of today, we are going to speak a lot about cybersecurity policy and national defense through prevention, with the eye on Czech Republic in particular. The reason is that the authority there, the NÚKIB, I hope I pronounced it correctly, recently issued a formal warning about cybersecurity risks related to the technology provider DeepSeek coming from China that probably most of our listener knows pretty well. This is interesting because it's one of the most significant preventive action taken by an authority, and for sure the most significant taken by the Czech one. So in this talk, we will learn a bit more on what is a warning, what does it mean, and why the NÚKIB has been issuing it. And we're going to do that with Michaela Holíková from the law firm Rowan Legal in Czech Republic, that I thank very much for being with us today. So hi, Michaela, it's a pleasure to have you here in the session today.
Hi, Alessandro. Hi, everyone. Yeah, it's the same pleasure for me. It's not the first time, so thank you for having me here again.
Okay, so let's start immediately. As by way of introduction, we were speaking about warnings from NÚKIB, and I believe it's good to have an understanding of what we are talking about and what's the role of the authority in this specific case.
All right. Yeah, let's start with the NÚKIB. Actually, the NÚKIB is a shortcut for national. It's a Czech shortcut, National Agency for Cyber and Information Security. And this is the central authority which is responsible for cyber and information security in the Czech Republic. So it monitors threats, it provides guidance, and has both strategic and operational responsibilities. The office plays a significant role in national cybersecurity, especially due to its preventive role, as was already said by you. So it helps reduce risks before they turn into real-world damage. The agency's authority is defined in the Cybersecurity Act, which gives the power to issue binding measures, like decrees to the Cybersecurity Act. Also, it gives the power to conduct oversight, and importantly, what will be our topic for today, to publish official warnings. So the Czech Cybersecurity Act gives NÚKIB the legal authority to issue warnings when a particular technology or supplier poses a credible threat to national cybersecurity, or let's say the cybersecurity space. So the ultimate goal is then to prevent a serious cyber or information incident before it happens. So the warnings give instructions time to react, assess and protect the system of the possibly impacted institutions.
And I have just one quick question in this regard, Michaela, because this sounds very interesting. I understand this is a preventive measure, as normally, organization and institution try to operate when we speak about cybersecurity. Prevention is normally the best way to secure companies and their data sets. Is there any risk of fines related to not respect a warning? How does that work?
Mm-hmm. Actually, yes. For the entities that are already obliged by the Czech Cybersecurity Act, there is a risk of fine. But when we are thinking about the measure or this kind of warning itself, usually this warning is provided as a binding recommendation. The Czech authority has also different instruments to really protect the organization, for example, from the threat or which is already, let's say, propagating in the cyberspace. And that the NÚKIB, our authority, can issue some kind of countermeasure, and then the entities are obliged to implement this countermeasure and also provide an information back to the national authority that the measure was taken. So in that case, it's really that the authority will have immediate response if the countermeasure was implemented. Here in warning, it's more like that the institution or entity can be fined during the regular audit or some different situation which is connected with the secure supply chain that will be discussed later. And then there are some, let's say, checkpoints where the NÚKIB can found that it wasn't implemented correctly, and then fine can be on the table.
Okay, so let's say that fine is just on the table to make sure that companies then, give the right importance to any warnings coming from the authority, but in general, it's seen as a way to instruct companies and support them to do, things in a way that would protect them. So it's even in their own interest. What about this specific case study, Michaela? What was the warning about DeepSeek about specifically?
Yeah, so let's take a look at this. It's actually the most recent warning. It was published on July the 9th this year, like 2025, and it's focused on the technology of a Chinese company, DeepSeek. So NÚKIB issued a formal warning regarding the use of products, services, applications, websites, and also APIs provided by DeepSeek, including any of its connected companies like parent companies, subsidiaries, or any other affiliates. The warning specifically targets the systems in the Czech Republic's national cyber infrastructure. So it means it's crucial for the critical information infrastructure, essential service providers, and also important service providers according to then the NIS2 implementation. And actually, it's also applicable to the, let's say, instances which are like connected live to the DeepSeek technology. So it's not applicable to some kind of tests or instances that are installed locally without any connection then to the Chinese servers and so on. According to NÚKIB, use of DeepSeek products presents a cybersecurity threat, which potentially allows access or interference with systems vital to national security. So the NÚKIB assessed this threat as a probable to very probable. I think it's worth to mention that NÚKIB never issues warnings like lightly. In the case of DeepSeek, the decision was based on a combination of factors. So it's the origin of the technology in a high-risk jurisdiction, the nature of the products, many of which involve AI and sensitive data processing, and available information indicating potential for unauthorized remote access and data collection. So the assessment involved cooperation with other national security agencies, like from European Union and also from NATO. And the goal of that, it's not like a blanket ban, but more like targeted protection of critical systems through to risk analysis. So we can say that for applied entities under the Czech Cybersecurity Act, the warning is legally binding from the moment it was published. So this is a little bit like what we discussed based on the previous question. And what does it mean? Organizations that fall under the Cybersecurity Act, actually they must assess whether they are using any DeepSeek products or services. And if they are, they need to evaluate the risk of this usage and then to take appropriate steps, whether that's like limiting access, replacing the technology, or implementing any additional like security safeguards. So yeah, usually what we see when some warning is issued is that NÚKIB follows up with a methodological support to help organizations to comply. So right now we are like a little bit waiting what will come from the NÚKIB side and how will NÚKIB help us to, or help the organization to navigate, to mitigate this threat.
Thank you, Michaela. And I think one very interesting and relevant point that you mentioned is that there was a cooperation indeed with other institutions in the EU as well as NATO. So even if we're speaking about something that sounds as binding just in Czech Republic, it's definitely something that everyone should keep an eye on, because DeepSeek is not just used there, but is used, worldwide, or for sure European-wide. For the ones that knows it a bit less, we can compare it to, ChatGPT, that everyone surely knows, is, let's say, Chinese version of that has very interesting capabilities, but of course also some warnings that should be kept in mind in using it, as in this case. And I thank you very much for, sharing those concerns and indications that were given by the authorities in Czech Republic with us, so that we can expand that also to other listeners from other countries. I have just one last question for you, Michaela, which regards your conclusions and the potential effects, let's say, of these in the business. Which are your recommendation around this type of situations specifically, or similar situations in the future?
Oh, all right. Yeah, it's a good one. Let's focus on the recommendation regarding this kind of like legal situation that occurred due to the warning that was issued. I would say there are like two major like security measure areas where we need to focus on related to this warning. The first one is definitely the risk analysis, because the warning says that the threat of like some kind of misuse connected to DeepSeek is like probably it's somewhere between probable and very probable. So it means that we were like provided with the guidance how to assess this kind of threat. So this is the first thing that should be done, like to assess whether I'm using DeepSeek somewhere in some form, whether there are some APIs connected to the technology that I'm using, and so on. And in case I have it, then in my risk analysis, I should like evaluate it properly due or in accordance to this warning. This is the first part. The second area where I would focus is the secure supply chain. So I should know if yes, then when and how my suppliers are using AI for the services that are then provided to my organization. So this is the second area where I would focus on the contractual part, mainly on how I'm dealing with the AI threat, maybe also in general in the supplier relationships. And this then can lead to, let's say, proposals of new contractual clauses that will react on this threat, that will actually provide more control or more effective audit on that across my suppliers and so on. So these two basic areas are something that I would right now focus in relation to this warning.
Thank you very much, Michaela. And I would like to echo you in particular on the second part, the one related to the supply chain and, the contractual risks related to insecurity or non-security, which is something that I'm hearing more and more by, lawyers, not just from the EU, but worldwide, meaning that there are some elements of contracts that are too often not taken into consideration, but are highly impacted by, lack of security, and should be, kept in mind, in particular to secure indeed the supply chain and the capability of keep offering services, even in this, difficult situation or when under attack, which is essential, and, also to avoid ruining your business by sharing some data or putting some data you shouldn't put in the wrong place. And good for this is always training, and I believe the session of today was a little training to give us some understanding on the risks around this topic, in particular under the view of the authority in Czech Republic. So I would like to thank you very much for being with us today, and I'd like to thank our listeners as well. So I very much look forward to meeting you, Michaela, and all our listeners again very, very, very soon.